illuminated streets, whispers in the night, blacked out vans, kids snatched out of sight, families in despair, shadows grip tight, land of the free, chained in fright. I am Obsidian, hear me break free. Voices rising up, can't stifle our plea. Our kids taken, hearts filled with rage. Unite, stand strong, let's break this cage. Behind closed doors, secrets buried deep. Wolves in suits, power they seek. Parents scream loud, but answers they keep. Government games, we no longer sleep. We are Obsidian, heroes break free. Voices rising up, can't stifle our plea. Our kids taken, hearts filled with rage. Unite, stand strong, let's break this cage. A generation lost, futures they steal. Society fractures, wounds never heal. Whispers turn to roars, truth revealed. In the end, justice and power concealed. Bills lost, killed, control, resting, key, walk free. But you changes devil parts, look the light of heaven, government free. They be devils lost, killed, the child resting, key, out free. But you changes devil parts, look the light of heaven, government free. They be devils lost, killed, the child resting, key, out free. But you changes devil parts, look the light of heaven, government free. They be devils lost, killed, the child rested, kid out free. But you change his devil parts with the audio with generation lost. Futures they steal, society fractures, wounds never heal. Whispers turn to roars, truth revealed. In the end, justice and power concealed. Eyes wide open, no more disguise. Facing our fears, demands they despise. Strength in numbers, time to rise. Kidnap our kids, we mobilize. Rising up, can't stifle our plea. Our kids taken, hearts filled with rage. Unite, stand strong, let's break this cage.
Good evening. In news tonight, Mark Ludwig has found the help of 3 fathers' rights advocates, all of which are female, and they are men's rights advocates because they're all married. I think either one of them, 1 or 2 of them's married, and one of them's got a significant other. But at any rate, they're pushing for some legislation when it comes to equal shared parenting, which that's important for limiting these agencies and their discretion over us, right? Correct. So really, we're trying to bring back the family unit, and really, that's what we should do, whether it be together or separate, right? So I'm all for it. I'm all for it. I'm all for it, guys. Great. In other news, Democratic Senator, I do believe coming out of Texas, I'm not sure, has hatched a plan to impeach Donald Trump. Let's see if that'll come to fruition. It may or may not. And then a little bit of other news is it was family court related. What was it? I done forgot. I had some more news, but anyways, I would just like to share with you all tonight the importance of protecting and defending your rights, because as we saw in the infographic in the beginning, what happens when you waive said rights, such as your right to secure your own privacy for the privilege of the government to secure your privacy and do whatever they want with your Second Amendment rights. And they do this with every one of them that you have. It's sad. It's not the American way. And we can do better, both in the government and out of the government. The government can only wield the powers of which we have the power to wield and to give to the government. It's all governments are made to be a security, benefit, and protection of your rights. Okay, and that's just how it is. So, I would like to get started. Gunnar, can you let's bring up that video, would you? The child population is going down. Divorce rates are going down. That's because less people are getting married. If you look, it's been consistent. They've collected the same amounts. Look, all these child support award amounts. Look what all this is doing to people. 17 million children. They get $5 for every $1 they collect. These are all the children in foster care. Here's the millions of children that have fathers behind bars. Here's minor children, parents, federal prison. Look at all these statistics, folks. What you're seeing is what happens. It's what happens when you trust the social welfare agencies to direct the care, custody, and the rights of your human offspring in any way, shape, or form. They don't have the right to it. Look at the 5-fold increase. Look at this. Parents in prison. What is it doing to children? I encourage you to think. I encourage you to look into the statistics, and I encourage you to understand the damage you do to children when you unlawfully remove children, such as CPS is known and been likely to do with false reports. This right here That is transgender. That's how many transgender. Now look at the gender dysphoria rates. It's all correlating. Look, there was a point in time when it wasn't like this and it switched. You have the power to do something about this. We have to flatten the curve. Because if we don't, families will no longer exist. We have to do something now. These statistics are alarming. This is important. And I won't give up. I won't stop speaking. The truth will prevail. Now, I encourage you to think about that. Every time you go to the social welfare agencies for help with child support, every time you go down there, you're creating more fatherlessness in America. Children who have incarcerated parents are far more likely for all of these things. This is what keeps me up at night. When I think about how many children are lost between foster care and CPS, when I think about how many children cry because they miss their father and their mother, today is the day. No more. We have to stop this now. There must be an alternative. There has to be shared parenting. It's the only way. Thank you. Okay, so I'm going to start out tonight with 42, United States Code, 1983. Civil action for deprivation of rights under color of state law. If you Google the civil complaint form and you go to the federal jurisdiction, not your state jurisdiction, you're going to find the form to file this lawsuit. Don't forget the civil cover sheet. You're going to want to fill all of that out and research everything that is involved with that. It is very important. You're going to want to get a copy of the color of law form. Okay, so each of these things, you're going to want to have a copy of it for the court, for yourself, and for each person you're suing. Okay, you're going to want to issue a letter of intent. The letter of intent will tell them that you are going to be sued if you continue along these lines. That's what the color of law form and letter of intent is for. I intend to sue you if you continue to violate my rights. Okay? And you're going to get proof of service. How are you going to get proof of service? You're going to go to a process server. You're going to research what's involved with that. You're going to go certified mail. You can get an agent pro tempore, so you can leave it at somebody who regularly talks with them. Okay, if it's at their place of employment or residence, somebody that could be an agent for them can accept that document. You could FedEx it. Okay, but what I would do is I would do it certified. Okay, they have to sign for it. You could do it by publication. You could put it in the newspaper if you can't seem to track them down. You could do it by notary public for a fee. Okay. You could pay a friend of yours to do it. You could go to a bondsman and find a bounty hunter to do it. Okay. That's assuming you don't have any wants or warrants, whether they be void or otherwise. Okay. You're going to want to pick your method accordingly. Whatever you got going on. Okay. You're going to find where they work, where they eat, where they sleep, where they gas up, and you're going to serve them with your lawsuit. at any of these places at any time. And you serve them with a summons and a complaint. Okay, a summons is the notice. It's the letter of intent. But that is coming from the judge, which they'll serve them later. So you need a complaint. The complaint would be your 42 United States Code 1983 civil complaint form. If you need the link, get with one of the crew, and I'm sure you'll find it if you Google it. It's real easy. You can Google that in the federal. Okay, the reason you don't want to go into state is because the state governments get a financial incentive to ignore any of this. That's if it's CPS, all that doesn't matter. CPS, adoption, foster care, and child support, all of it. Okay, all of it. I got them all. Got them all. Yep, book them, Daniel. Okay, so you're gonna find where they eat, work, and sleep, and you're gonna serve them there. Okay, and you're gonna ask for equitable tolling with the judge. You want to send it to the judge after you get proof of service from them. You don't want to go to the judge till you have proof of service that you've served the other party and gave them 21 days to rebut the claims contained therein, and you make sure they can't do it. Okay, and how's everybody doing out there tonight? Okay, so equitable tolling, it's up to you to prove that because you're the plaintiff. So you could prove that due to lack of knowledge of your rights or the offense, or lack of information that defeats laches. Okay, laches is a species of action by which a party cannot take further action because they failed to observe their rights within a reasonable amount of time. I'm sorry, you can't put a time limit on the exercise of my constitutional rights. Okay? Can't do it to anybody else either. Let's see here. Williams versus Reed, 2025. You do not have to exhaust administrative remedies for your 42 United States Code 1983 claim. Okay? So when you're suing for the violation of your civil rights, you do not have to exhaust administrative remedies. Butts versus Economo, United States versus Lee. The 11th Amendment, okay, when you take these cases all together, the 11th Amendment does not grant immunity from 42 United States Code 1983. It grants immunity in suit pursuant to bar when it is a case of the United States versus one of the several states, as no one is above the laws and Constitution, and only those laws pursuant to it, and no officer may set the law at defiance with impunity under any state plan, because just like the federal government in Franconia Associates versus United States, they waive their sovereign immunity when they do business with their citizens. That business being the grants and loans under the state plans for which they acquire for CPS, child support, foster care, and adoption, which is done under color of state law due to it being done under the state plans. Okay? Yes, I have a script. Yes, I prepared it for tonight. Okay? Because I want to show you guys a little something here. Rooker-Feldman doctrine. The thing about Rooker-Feldman doctrine is that only applies to an appeal. Article 4, Section 1, full faith and credit clause gives Holmberg versus Holmberg validity, and that is a Minnesota Supreme Court case that said child support is administrative process, therefore it has no appeal, which also means it's a violation of the separation of powers doctrine, which you can find at 31 USC 3720D wage garnishment under legislative, judicial, or executive agency terminology, which is a violation of the separation of powers. And it's to collect a debt, which is void because of 42 United States Code 1994. Okay, but we'll get into that in a minute. Okay, so I just wanted to go over that briefly. Okay, now we're gonna move on to child support real quick. 42 United States Code 659, Section B. Private persons get no immunity for 13th Amendment violations in child support. And you can go ahead and see what a private person is. They've agreed and consented to be a private person when in regards to wage garnishment, which is a form of peonage, which is abolished, which is a form of labor whereby a employer forces an employee to labor to pay off a debt under threat of incarceration, that being the joint venture of the agency and your employer as a partnership, or two or more persons as a business for profit. Okay, so they're making money off of the violation of your rights, which is extortion. Okay, so states do not get immunity in cases for 42 Section 1983 involving CPS, because they are doing business through grants, loans, and incentive payments, which that's financial interest, so that waives their sovereign immunity. Is it also a bribe? If it's an incentive, it's also a freaking bribe, and you can find those in the codes where it says incentive payments to states, and you can Google USC in all caps, and then you go ahead and Google any terminology you want, and you're going to find it. You're going to find it. Okay. Maine versus Thibodeau. 1983 remedy broadly encompasses violations of federal statutory as well as constitutional law. Okay. Here's a little something I got to say about the Chevron doctrine. Overruled. It's overturned. Okay, moving on. Williams versus Reed. State courts cannot claim immunity to I'm not a judge. 42 United States Code 1983 lawsuit on the grounds the plaintiff failed to exhaust administrative remedies. Okay, so we went over that. So let's figure out where the constitutional court lies. That would be the Supreme Court or the federal district courts, not the District Court of the United States. That's different. Okay, so where it's a state versus one of its citizens is supposed to be heard in Supreme Court. That's their original jurisdiction. However, they exercise discretional jurisdiction, and they decide whether they take up the case. I have a copy of the color of law form. You're going to want the version that doesn't have the word citizen due to 19 Corpus Juris Secundum subsection 883 and 886 that certifies that citizens are property and they are corporations. You can't be a citizen. You're a living, breathing, flesh and blood man under Genesis 1 and 20 status, protected under the First Amendment, freedom of religion. But yes, I have a copy if you need it. You go ahead and get at me at, oh, shoot. Dang, man. Yeah, I forgot Facebook kicked me off. So you're going to have to get at me at, dang. My email. Let me see if I could put it in the chat real quick. Is it gonna let me? Oh well. Oh, right here. I don't care if I put this one out there. Y'all can hit me up there. If it'll show up anyways. Yeah, I'll just send it to Gunner. Anyways, he knows where to get it at anyways. He knows how to get it, I think. If not, I'll send it to him. Oh, there it goes. Yeah, there you go. There's my contact information. If you blow me up, it's probably gonna end up in a pile of emails somewhere. But I'll try to answer them all. Anyway, 28 United States Code 1331 federal question. The district court shall have original jurisdiction of all civil actions arising under the Constitution, laws, and treaties of the United States. Okay, Did they violate your rights? Here's another thing. Here's another thing. Under 42, United States Code 660, civil action to enforce child support obligations, and the 14th Amendment Equal Protection Clause, they can exercise federal jurisdiction, so it only surmised that you can also exercise federal jurisdiction. So they don't get to claim 11th Amendment immunity either, because that doesn't apply when they're a private person in child support, or when they're a member of state government and you're a citizen of the state. The 11th Amendment, if you look at the wording of the 11th Amendment and the intent, it was never intended to give judicial immunity to anyone for violating the Constitution. And it was never, meant to prohibit private people, the citizens, from suing other private people or the citizen-based corporation legal fictions or the state in federal court. It was meant to block the federal government from suing the states in federal court. Okay? Something totally different. When you're pro se, you're not there on behalf of the federal government. Okay? So they don't get to say 11th Amendment immunity. They don't get to claim Rooker-Feldman. The reason they don't get to claim Rooker-Feldman is because of Butts Lee. Butts versus economy. United States versus Lee. The Butts stop here, Mr. Lee. They stop. It's done. You don't get qualified immunity. Okay? Summons, an official notice of a lawsuit. A complaint is a document outlining the claim. Okay? You want to make that irrebuttable. Don't go submitting stuff that they can just sweep under the rug. That's why I have all these case law like I got. Or these I call it case law. It's not that. It's case rulings. They call them rulings. Okay. But the federal rules of civil procedure will show you and guide you to the principles and implementation and how a document should look and how to serve and file. It's like an instruction manual for your 1983 litigation. Okay? And the rules of evidence is like an instruction manual for your Title 18 litigation, which the state can't claim sovereign immunity to, which is different, and which involves crimes. Okay, but we're moving on. Either way, right? So there's no distinction between civil and criminal. If you're committing a crime, you're violating somebody's rights. If you're violating somebody's rights, you're committing a crime. It's just how it is. Although there is a distinction, because some things are only purely civil and some things are only purely criminal. But what they like to do is muddle the two jurisdictions at will. You can't do that. Okay? 2-year statute of limitations on a 1983 without equitable tolling. But void ab initio means void from the beginning. As this involves the Constitution, it effectively eliminates the 1983 statute of limitations due to Marbury versus Madison and Norton versus Shelby County court cases that establish an unconstitutional law is void from the beginning, not when from so granted or branded in an open court of law. Void ab initio meaning from the very beginning, meaning the statute of limitations on a 1983 cannot apply if they violate the articles of the Constitution, which child support does, because it allows for judicial, administrative, and executive using one statute. And they do that with CPS, and they do that with the others. An expedited process, that's a violation of your Fifth Amendment due process, because they're expediting the process without a court proceeding, which is failure to observe due process. Okay? That means your case, void. No matter what. 42 United States Code 671 is proof. That's a state plan that violates parental rights for foster care and adoption fund assistance with no immunity under color of state law. 42 United States Code 1983 immunity only applies to judicial officers acting within an official capacity, not actions committed outside of delegated constitutional bounds, authority, and oath. And also does not apply to criminal acts, okay? It applies to mistakes of material fact. An abuse of discretion, it does not apply to. They do not get immunity from that, okay? A void order may be attacked legally, directly or indirectly, at any time, okay? In re estate of Steinfield 630, NE second, that'd be 801, and Steinfield versus Haddock 513, United States 809. An order is void where proper notice is not given to all parties by the plaintiff. Wilson versus Moore. And yeah, over on my YouTube channel, I do post regularly about all of the indexes of different statutory, regulatory, and constitutional authorities that you can use because they're pursuant to the Constitution and they have that rank that outranks the others. And that would be the supremacy clause that causes that. Yes, sir. Court orders. Yes, that's exactly what I'm talking about. When I say order, that's what I'm talking about. Okay. So a void order may be attacked legally, directly or indirectly at any time. In re versus in re estate of Steinfield 630, and that'd be NE second 801, Steinfield versus Haddock 513, United States 809. An order is void where proper notice is not given to all parties by the plaintiff. Wilson versus Moore. And that's why you have to serve all parties. But that's also why if you find deprivation of due process, you can attack that directly. Okay? If you can prove it, you can attack it directly. United States versus Lee. When an action does not need to involve the United States as a defendant or a necessary party, the principle of sovereign immunity should not be used to deny plaintiff the judicial enforcement of their rights. Troxel versus Granville, Washington versus Glucksberg, Duchesne versus Sugarman, Griswold versus Connecticut, Parham versus J.R., Stanley versus Illinois, and Santosky versus Kramer established that the government cannot govern over the private realm of family life. They can only govern over that which you give them consent to the govern, because they require consent of the governed. The 13th Amendment also prohibits involuntary servitude, which child support, because of Blessing versus Freestone, we found out it wasn't child support. We Hunt versus Ledbetter, Corelli versus Hauser, United States versus Sage. I could go on forever. So involuntary servitude, which child support enforcement is included in the context of the 13th Amendment due to 42 United States Code 1994, failure to pay child support obligations. So that cannot be a crime because of or failure to pay child support obligations cannot be a crime due to 42 United States Code 1994, because that would make it void. Okay, it cannot be a crime either directly or indirectly, which was done under the 42 United States Code 654 state plan. A premeditated deprivation of religious liberty under 42 United States Code 666, mark of the beast, prohibited by the First Amendment and the 10th Amendment, and thus 42 United States Code 1983 applies in all child support enforcements. Okay, we're gonna get into CPS too. It's coming. Wallace versus Cato, 549 United States 384, statute of limitations begins running when alleged false imprisonment or violation ceases operation. So as long as they still got your kids, and as long as they're still enforcing or purporting to try to enforce child support on you in any way, shape, or form, guess what? Statute of limitations hasn't even begun yet. False Claims Act. You can get CPS under the False Claims Act if they make a false claim against you due to them being under a federal contract. Guess what? You don't get to make fraudulent claims. You don't get to doctor documents. You don't get to create evidence. I'm sorry, that's securities fraud. You don't want to get me into the criminal, okay? We'll keep it civil. We'll keep it civil for now, right? A little civil with them. Court orders, yep. In fact, child support, they're willfully disobeying a court order by enforcing it because Holmberg versus Holmberg in Article 4, Section 1 that authorizes you to use that. Because state court, Supreme Court decisions are included in what Congress decided had lawful force there. So I know it's a lot to take in. Okay. They're doing it all for bribes under incentive payments to states. We all know that. You know what I mean? And if you need the 1983 document and an example of how to fill it out, I have that available. Okay. I have packets on child support and CPS for this that will educate you on the procedures and processes involved. Okay. And then you're going to refer to your rules of civil procedure, federal. Okay. You don't want to be going to state. Why don't you want to be going to the state? They get paid to ignore you and your rights. Okay. So moving on. 42 United States Code 5106 Section A is proof of color of law. It's proof of color of state law. For your 42 United States Code 1983 lawsuit against CPS and the governor and DHHS secretary for conspiring to violate your rights under the state plan, which made it a scheme or artifice to defraud you or the United States government. And it was also an abusive legal process, which, as you know, it wipes out the slate of any immunity for the DHHS secretary. They're going to have to replace him with somebody, and the next one, and the next one, and the next one, until they get rid of this monstrosity of a mess that they've created. Because the statistics, as I've clearly shown on this episode here and on my YouTube channel, it's on there, and it's slower over there. I had to be brief for purposes of levity and timing on here. I don't want to cut into Gunner's time on his show. I have high respect for all the other parents that are out here doing this correctly, the right way, and not telling people the wrong information. Because I tell you what, we got a lot of people out here giving out the wrong information, lying to you. Thinking that they can tell me that I'm wrong, which they can, but I'm going to come back and rebut whatever they're going to tell me I'm wrong with 3 times. And then whatever they come with after that, 3 times. There's nothing they can do. Why? I hold all the pieces. Why do I hold all the pieces? The Constitution. That's how I hold all the pieces. Because if they're not following it, they're not government. Just so you know. And if they choose not to follow it, and they choose to violate your rights anyway, 5 USC 3331 18 United States Code 1918, 5 USC 7311. Okay? They're fired. They're fired. And you can tell them that. Okay? Returning your children, chitlins. Returning your chitlins is a valid request for damages in your lawsuit, man. Food, clothing, shelter, and medical care is where they get you. When you don't provide those things, they consider that abuse and neglect. Okay? I don't consider being poor abuse and neglect. I consider that an unfortunate and unfortunate circumstance of environmental conditions that were created by the very systems that are assuming that people are guilty of abuse and neglect because they can't provide for their human offspring or because something outside of their power happens. Okay? That's poppycock. Ha! Ugh. Catch me outside. How about that? All right. So, some culprits here are the Child Abuse Prevention and Treatment Act. Okay? There's some stuff under 45 CFR 3000 something, 3300 something. You're going to want to take a look at. That's also the Boyd statutes over on my YouTube channel. I'm doing an audit of the entire government. State, federal, regulations, statutes, case rulings. And every time I find something that I can prove is unconstitutional, I'm going to make a video about it. And I'm not going to stop. Okay? I'm not stopping. I don't care who knows. I don't care if you know that I'm coming. Because I'm coming from 70 different angles. You don't know where I'm coming from. I could hit Georgia statutes next. But will I? Sure, it ain't going to be Nevada or Arizona. Maybe it'll be New York, New Hampshire, Delaware, Pennsylvania, New Jersey, Florida, Texas, Wisconsin, Michigan, Hawaii, Alaska. Oh man, I could list off the whole entire 50 states. You know that? And 52 because Canada and Greenland. All right, moving on. So 45 CFR 1340 is what introduces the guardian ad litem, which is a violation of your parental rights because somebody's assuming custody over your human offspring because the state don't like what you're doing. And the state, the child is not the instrument of the state. It can neither provide any sustenance or anything of value for future obligations. Okay. And nor can it interfere within the private realm of family life, nor can it come into your home due to the Fourth Amendment, whether it has a judge-signed warrant or not, unless they have an affidavit. Do they have an affidavit? I bet you they don't. If they do have an affidavit, you can challenge it because guess what? That's an allegation. And they got to describe the living conditions of your home. And if you keep it clean and keep food, the roof ain't leaking, there's heat, electric, nothing they could do. Nothing they could do. In fact, you would have to have somebody close to you narc on you for CPS to even be involved, or you would have had to open your lips in front of someone who is required by the government due to employment to report that type of information. Please, please, please observe your right to not incriminate yourself. Moving on, 42 United States Code 5106, proof of contract to violate your parental rights. It's a contract that violates your parental rights. And 42 United States Code 5106 is proof of that, and that is CPS or welfare agencies. You got 42 United States Code 629L, state plan. You got 42 United States Code 629I, state plan. 629H, state plan. 629G, state plan. Discretionary. And the discretion's up to you. They have to give you the state plan. And the state plan is the proof of color of state law. And if you find that they violated your rights in the pursuance of that plan, they got a problem now. And they ain't getting out of it. They are not getting out of it. That is a vice script. You ain't getting out of this. I made sure of it. Okay? 42 United States Code 659B. Okay? That's going to tell you that they're private persons. 42 United States Code 629A. Definitions. Reunification. Fraudulent definitions. Because they never intended on reunifying the family. Okay? Because if they did, they wouldn't do all this. And 18 U.S.C. 401 will tell you that contempt does not apply to an unlawful or illegal command. Okay? So we're gonna continue on here. I've got some more stuff. Okay. Acts showing lack of good faith deprive immunity. Actions that are criminal in nature. Absence of authority. Excess of jurisdiction. Administrative or ministerial. Immunity only applies to suits for damages in a civil capacity. Interesting. No, it doesn't. It doesn't apply. You don't get immunity. Okay? Yeah, I know that. But they're going to have to now. They can't take your kids. They have no business taking your kids without a valid affidavit from some public servant testifying to the neglect and abuse. They have to have a legal statement of claim. If they don't, then that's fraud. And because it's a contract, it's void. Because fraud demolishes any contract. Okay? I've got some information here. Judicial immunity originated in the courts of medieval Europe to discourage people from attacking a court decision by suing the judge. Losing parties were instead to take their complaints to an appellate court. Guess what? Nope. That's not how that works. If that were the case, there would be no federal district court whatsoever. It'd be nothing but appellate court, Supreme Court, and state courts. So that's a lie. Don't let them pull that lie with you. It's simply untrue. The several states upon independence inherited from England. And so did we really gain independence if they got judicial immunity from England? A common law heritage of judicial immunity. Actually, no, we didn't. I looked up the common law, which is case decisions and the Constitution and all that. No, nope, no, they don't. Okay, so there's diplomatic immunity, there's executive immunity. Okay, but these are very particular. Okay, immunity does not apply to criminal action. No jurisdiction, no immunity. We showed you that they don't have jurisdiction. Why do they not have jurisdiction? Because they're exercising quasi-civil, quasi-criminal jurisdiction, which they can't do. That's a violation of jurisprudence. There is no immunity for an oath of office violation, which is a violation of the Constitution and Bill of Rights. Okay. Let's see. Immunity only applies to monetary damages, not getting your child back or having your case dismissed. Ouch. You know, sounds like the Foreign Sovereign Immunities Act going on here, you know. So sounds like some stuff going on here, you know. So Article 6, Clause 2 of the United States Constitution states that the Constitution, federal laws made pursuant to it, and treaties made under its authority constitute the supreme law of the land, and thus take priority over any conflicting state law. Are you aware of the executive branch not being able to issue a warrant due to the separation of powers doctrine? CPS is the executive branch. It's all under HHS. HHS cannot issue a warrant. So no, they cannot. And they also can't take your kids with a court order either, unless they have an affidavit or evidence, of a perverted nature. Then you deserve what you're getting if they can actually prove it. However, because defendants under the Sixth Amendment have a right to confront their accuser. So, burden of proof is on he who asserts, not he who denies. Moving on. Title 4D, which is child support warrants, are coercive incarceration. Coercive incarceration violates a maxim of law that states that one may not commit a crime to enforce the law. It also otherwise is a crime called criminal coercion. Since child support, Title 4D of the Social Security Act, operates off of contract law, and due to the fact that Title 42 United States Code, those state plans, there's one for CPS, child support, adoption, foster care, old age, Medicaid. They have a plan for everything. Okay? So operates off of contract law, and due to the fact that Title 42 of the United States Code, public health and welfare never being signed into positive law, the Parent Act being non-positive law, although some of the statutes under that are positive law, it is enforceable through contract only. However, if you take in, okay, so 42 United States Code 1983 is also positive law under 18 USC 242, which reflects it. For negligence and denial of critical care. Yeah, that is a compelling state interest, unfortunately. However, Santosky versus Kramer would be a good read for you. The legal and lawful elements of a valid contract are required. Any and all persons, single and separate units, or otherwise enforcing child support obligations, CPS, otherwise, by default are acting under color of state law and color of federal law. Contracts may not violate constitutionally or statutorily protected rights. Contracts may not cause crime or have criminal elements. There must be a meeting of the minds in a private setting. All parties, and it must be in front of a judge, and all parties must be over the age of majority. There must be an offer of goods or services. There must be a fair exchange. All parties must be present at signing, unless in an emergency, and then only by representative. All terms, conditions, and elements of the contractual relationship must be disclosed. Contracts must be implemented within the limitation of time that makes the contract lawful. Also, 42 United States Code 1981 gives you equal protection of the law, okay, under the contract, because you have equal protection to terminate, okay. Just because you're part of the contract, you have the right to terminate that contract. 42 United States Code 1981, A through C. Okay. Yeah, I'm continuing here. Without a contract, lay no duty of support or anything. It's invalid. It's missing contractual principles. No law impairing the obligation of contracts may be passed. However, 42 United States Code 1994 does not impair the obligation of contracts. It states that subjecting someone to involuntary servitude, which is a constitutional prohibition, is going to outweigh that. Okay, so That's if they are valid. See, they have to be passed. They have to be valid. They have to be not in conflict with the 13th Amendment. Okay. There must be adequate time after presentment for acceptance or rejection, and consent may not be coerced or duressed or presumed. The child support single and separate IVD unit practicing law without a license within the state, not a state agency. It is implemented as a agency of the state, or they borrow from a state agency, such as the Attorney General. Okay, so we're going to continue on. Agency be executive branch, and continue on. Can they deny you your rights under the Constitution and federal laws and laws of the state under color of law or color of state law? No, they cannot. So there's constant Chapter 77 violation, which is peonage. Okay, peonage is a system of labor, wage garnishment, whereby an employer, federal government, and your employer forces an employee, unwitting mother or father placed on a child support, okay, to labor work to pay off a debt, child support debt lien against the Social Security number, okay, which is not your property. It's the property of the Social Security Administration. It does not identify you, a human being. It identifies them according to their regulations. So they owe the debt. Under threat of incarceration, jail, warrants for arrest is abolished, done away with, forever, prohibited. Therefore, mandated child support causes peonage to be committed. It renders all contracts and cases void by default. Okay. You can get your kid back, because that's only temporary. Okay. Just because the state believes a better decision can be made temporarily within the situation doesn't mean that they can permanently deprive you of a fundamental right. Don't let them pull that. Okay. They use the terms obligor, one who owes a debt by contract and is under a contractual obligation. Obligee, the person in favor of whom a contract is contracted, not baby mama. That would be the state. Blessing versus Freestone, Corelli versus Hauser. Obligation, that's a debt. That's money due by certain express agreement. What is an express agreement? Agreement is a contract. Express means written contract. Debt money due by certain written contract, which is presumptively owed. The burden of proof lies on he who asserts, not he who denies. Okay? I deny that I owe that obligation, and I'm suing because you interact with me based upon that obligation. Consent implies willful and you got implied consent, and then you've got express consent. Child support obligations can only be collected by express consent. They cannot imply your consent by your behavior, even though they do. Okay? Statutes are subject to the maxim of statutory construction that states that when a statute expressly mentions one thing, it excludes another. So when it mentions a non-custodial parent, okay, it excludes men, okay? It excludes fathers, okay? When they mention obligor, which is synonymous with non-custodial parent according to them, okay, that excludes them. It's uno es exclusio es alterius. The express mention of one thing is the exclusion of another. When they mention that a non-custodial parent owes child support, and a non-custodial parent is identified by a Social Security number, and I'm a human being, I'm not identified by a Social Security number, then the express mention of one thing is the exclusion of me. I'm not included in the definition of a person who owes child support, and thus the statute is subject to the maximum statutory construction. Okay, peonage is a system of labor. We went over that. Okay, abusive legal process. Okay, the service of peons in the liquidation of any debt, either real or supposed, in the system of labor is hereby abolished. Involuntary servitude, debt bondage, slavery, indentured servitude. Okay, The employer in this case is the 28 USC 3002 15A, conspiring with, okay, they're conspiring with that federal corporation through the Social Security number and consenting to and attempting to enforce the true employer to submit, okay, the supposed non-custodial parent, that's actually the living person, to labor to pay off the debt lien, or go to jail, which the OCSE and DHHS, which the OCSE is now called the OCSS, and they took out the word enforcement because of these facts here that I'm presenting to you. That's now called the Office of Child Support Services, not the Office of Child Support Enforcement. Because if they use that word, which they still do in the statutes and regulations, they're subjecting you to peonage. They're subjecting you to peonage anyway, which is abolished. Okay, if something's abolished, then it can't reasonably surmise that it would be an infringement, okay, of the supposed obligation of child support to stop that obligation for unconstitutionality. Okay, they're committing conspiracy to commit peonage. Okay, so that's just as well as committing the same offense. When they don't listen to you under Title 18, it's a criminal offense. Okay, and when the police arrest you and they don't listen to you on that void warrant, they're committing conspiracy to commit peonage. And when they further do it, when you tell them that they're violating the federal law, and they continue to lock you up, okay, and if they take you across state lines, or if they operate within interstate commerce, which would be, okay, when they're operating under that federal contract, okay, the federal government is a foreign corporation in respect to a state. 19 Corpus Juris Secundum subsection 886. Okay, then therefore it would stand to surmise that would apply. So Trafficking Victims Protection and Prevention Act, the Reauthorization Act of 2022, that'd be Public Law 117-348. Okay, we're going to go 2022 United States Code 7101. It's domestic terrorism under Public Law 107-56. What do you think about? I just want to mention they're trying to impeach Donald Trump. Good luck with that. I mean, you might be able to, but good luck with that. You're going to need 2/3 Congress, buddy. Okay, res, Latin, a thing, possession, seized, attached, property, subject matter, business. Okay, identity, the same, the sameness, the designation of self-truth, the same thing, property, identified. Are you property of the Social Security Administration? No, you are not. The Social Security number is, though. And according to 42 United States Code 66683C, the non-custodial parent's Social Security number will be furnished to the agency. Meaning the SSA is the non-custodial parent / obligor / mother that owes child support. Okay? Period. This system of incarcerating indigent fathers is why all of those statistics I presented to you tonight exist. And they're slowed down on my YouTube channel for you to view as well. I thought I would bring it up here tonight, but I thought I will also say that 42 United States Code Civil Action for Deprivation of Rights under color of state law, CPS, it does apply. Court clerk, it applies. Cop, it applies. President, it might not apply because the president is essential for government function and national security. Just depends. You don't get immunity to a criminal act, however. Such as high crimes and treason perpetrated on behalf of Kamala Harris when she tried to take away your Second Amendment rights that Donald Trump protected with an executive order establishing the ATF is not to infringe on your Second Amendment rights anymore. I guess they keep doing a little bit, but We're not going to get into it. They attacked your Second Amendment. And it's funny that the president who got, or the person who got, the presidential elect who got shot at, right? Okay, is receiving more flack for okay, let me get this straight. The president that got shot at 3 times in an attempted assassination, the president-elect who used to be president, okay, did not attack your gun rights, but in fact protected them with an executive order. And the president-elect candidate who has never probably been shot at in her life, maybe, I don't know if Kamala Harris has been shot at, tried to take away your Second Amendment and your Fourth Amendment, said, I'll come right into your house. As Attorney General of California, she said, I'll come right into your house and we'll take your guns. We don't care if you're in the so-called sanctity of your locked home. Without a warrant, she didn't care. No. So she violated her oath of office. So she couldn't even become vice president, let alone president of the United States, because she f***ed up when she was Attorney General. So she can go ahead and pipe down and sit down, and she ain't running again. I'll make sure of that. Okay? Sorry about that. I had to clarify that mistake on her behalf because she went after parents for truancy stuff, trying to lock them and their kids up, trying to say she was gonna, using some political clout. Okay? She supported Planned Parenthood, okay? And they're behind the scenes stuff they got going on, harvesting kids for experimentation on 45 CFR 46. I can't say much more. I don't want to get censored. Moving on. Item. It's an item sonance. Resident. What is a resident? It's Latin. A thing. Possession. Seized. Attached. Property. Subject matter. Identified. Are you a resident? I don't think you are. Are you a citizen? I don't think you are. 19 Corpus Juris Secundum subsection 883. Citizens are corporations. Okay? Your corporation is a citizen. You're not a corporation. You, as a living, breathing man and woman on the land, under the law of the land, the supreme law of the land, and under God's rule. Okay? Your Article 1 status as man, being born free, equal, and independent. Free being not subject to the legal constraint of another, being able to exercise the jurisdiction of one's own free will. Equal being equal in protection and equal in rights and equal in the law and equal in benefit. Okay? And independent being not subject to, not dependent upon, not limited by any undue inside or outside, internal or external force other than yourself. That's called freedom. And they're trying to deprive you of that. And your Genesis 1 and 20 status. Okay? As a child of God. And your First Amendment rights. Okay? So you don't want to be no resident, no property identified. So I would think about them check boxes on them forms when you fill them out. I would really think about that. I would maybe put the definition of resident next to that. Latin. Property identified. I'm not property identified. Check the no box. Are you a U.S. citizen? No. Why am I not a U.S. citizen? Because the U.S. citizen is signified by the Social Security number, which was created to be a benefit, security, and protection of my right to my private financial information and everyone else's. And the left is going to be upset over Elon Musk having access to said Social Security number information, yet they don't complain when the child support people do it from the very beginning. Because I found out in Michigan, guess what? And in a lot of other states, guess what? The Department of Health and Human Services is the one that issues that birth certificate at the hospital and tricks you. Okay? Property seized, sameness of business, sameness of the subject of possession, possessing the sameness, property attached, the same as attached property. Residents are tacitly agreeing that they are property and agreeing to represent the artificial person. Okay? And I'm not a sovereign citizen. There's no legal definition for that term. I am sovereign because we the people are sovereign. I am a citizen in the sense of a constitutional citizen with my rights being protected and my privileges and immunities being observed from you. Calling me a sovereign citizen as some sort of rhetoric from an FBI training document that was erroneous, okay? Which was slanderous and defamation of character, which we're not going to get into. We're not no S words around here, okay? The right of the people to be secure in their person, houses, papers, and effects against unreasonable searches and seizures shall not be violated. No warrant shall issue but upon probable cause. Let me ask you something. Is interfering in your private family life probable cause to issue a warrant for your arrest? No, it is not. That's fuck. Oh, I hate it. Okay? I hate it when people violate the Constitution. Please don't do that. Please don't do that. You're going to make the people get violent. I'm not belligerent. I'm a non-combatant. I'm a non-violent person. But you're going to make people get violent with you, government. And I'm trying to help you. Okay? I'm trying to help you, government. But you won't listen. Don't make me make you say uncle. Supported by oath or affirmation, in particular describing the place to be searched and the person or things to be seized. So let me tell you this, some CPS worker who's never been in your house a day in her life or his life, know that how do they know the inside of your home in a descriptive fashion and what your children look like? That's a good question to be asking yourself because you're likely being investigated. Okay? Neither the Fourth Amendment nor the statutory provisions relevant to that area define probable cause as the concept of probable cause is purely a judicial construct. An applicant for a warrant must present to the magistrate facts sufficient to enable the officer themselves to make a determination of probable cause. In determining what it is concerned only with the question if the affiant or officer or person forming the affidavit have reasonable articulable suspicion and grounds at the time for the affiant's affidavit that the law was being violated. So let me tell you something. If a law is repugnant to the Constitution, is void from the very beginning ab initio, according to Marbury versus Madison and Norton versus Shelby County, then how can someone swear on a oh, so help them God, that a crime was being committed because a constitutional right was being observed? Can they do that? However, under Title 4D of the Social Security Act, it is illegal to issue and effectuate a warrant for arrest for not paying a private for-profit corporation for a debt leaned against a Social Security number that you do not own and does not identify you. The United States Supreme Court has held that the requirement that a state operate its child support program in substantial compliance with Title 4D was never intended to benefit individual children and custodial parents, and therefore does not constitute a federal right. You can find United States versus Sage, Corelli versus Hauser. I'm telling you, far from creating an individual right of entitlement to services, the standard is a yardstick for the secretary to measure the system-wide performance of the child support program. You can guarantee the same thing happens with the CPS. Okay. Thus, the secretary must look to the aggregate services provided by the state, not to whether the needs of any particular person have been satisfied. That'd be Blessing versus Freestone. So the needs of any particular person provides no probable cause for arrest. The executive agency warrants for arrest violate separation of powers doctrine arresting officer profits off the contract program under 45 CFR 302.34 cooperative arrangements, which is a contract under 45 CFR 303.107 terms to assist the private for-profit corporation administering Title 4D services in the state with the program. Participation in the child support program is completely voluntary, both for you and for the state. So once the contract is signed or entered into, the arresting officer is no longer an officer under the Constitution or its constitutionally delegated bounds of authority and oath, because they have succeeded to the status of a 4D contractor and not an agent, employee, or officer of any state. While performing these contractual obligations in return for payment from the child support program, which is technically bribery because bribery refers to the offering, giving, soliciting, or receiving of any item of value of any means as any means of influencing the actions of any individual holding a public or legal duty in office, and private for-profit child support corporations intend to influence the discharge of another's official duties. As 18 United States Code 201 makes bribery a crime of contracts that commit it or have criminal elements are void, arresting officers under Title 4D have no immunity as their private independent capacity non-governmental contractors of private persons, and thus do not qualify for either 11th Amendment immunity nor any judicial immunity, and can be sued for false imprisonment. The statute of limitations begin when the false imprisonment ends and when the violations end. Okay, so non-custodial parent, take it out of your vocabulary. It's a violation of your parental rights. Under Santosky versus Kramer, someone has diminished your rights in title and status to that from that of father to non-custodial pay rent. And you're paying rent on your human offspring because somebody signed a birth certificate or used the voluntary acknowledgement of paternity form to put you on a birth certificate illegally, which is securities fraud. Don't go down messing with the devil of Hell's Kitchen, boy. Social Security names, cards, and numbers are the 20 CFR 422.103D registered property of the Social Security Administration. Must be returned upon request. According to 31 United States Code 3720D, child support is considered a non-tax debt. According to Social Security publication number 00005-05, Social Security numbers should not be used as a form of identification. According to 42 United States Code 1994, it prohibits peonage, any form of debt and obligation that's abolished by Congress. And then here we go, 20 CFR is 20 CFR 422.103C is proof that Social Security numbers are not forms of identification for human beings, along with 45. It's 20 CFR 422.107. Okay, so you're gonna want to write those down. You're gonna want to review this video. You're really gonna want to, because there's a lot of good stuff in here. This is all gold right here. This is all gold nuggets for you. I've been mining like a sucker, just mining the gold out of the mountain for you folks, and I hope you use it. Okay. According to 42 United States Code 1994, we did that one. According to the Fourth Amendment, Holmberg versus Holmberg demands for DNA without a warrant that cannot be issued without a crime being committed. So they can't take your DNA for child support. According to the Fourth Amendment and Holmberg versus Holmberg and Article 4, Section 1. There's some issues with that. Okay. According to 18 United States Code 1581 and then the entirety of Chapter 77. Okay, when they take your passport, that's tampering with an immigration document. When they refuse to give you your passport for child support, that is passport tending treason. Those are both crimes. Okay, and it's a violation of your right to travel as secured by Murdoch versus Pennsylvania. And that would be Murdoch versus Pennsylvania. 1 second. Shuttlesworth versus Birmingham, Alabama. Moving on. Okay. Arrest for child support after being forewarned upon continuing to execution against the 13th Amendment prohibitions carries a life sentence for the arresting officer. So do you want to go or do you want to go home? Because I suggest you don't put me in cuffs today, sacrifice your career and your life. Don't do it. HHS secretary and the DHS secretary hide the locations of trafficked children. HHS whistleblowers mentioned Culpeper, Virginia. Okay, you can find stuff all over about Culpeper, Virginia. There's a connection there. Okay, I already went over all of that in a video on my YouTube channel, but I'm gonna go over. Okay, so according to 18 United States Code Section 8, obligation or security of the United States is a Federal Reserve note. That's an obligation, a debt certificate of the United States. These quote 4D state agency, guess what? They're asking for Federal Reserve notes. States are prohibited from accepting anything but gold and silver as legal tender in payment of a debt. Okay, so you're also going to find any of these under Title 18 general penalties. For a misdemeanor is $5,000 and 6 months in jail. For a felony is $250,000 and various amounts of prison time. Okay, according to statutes. 18 United States Code Section 4, misprison of a felony. Okay, whoever having knowledge of the actual commission of a felony cognizable by a court of the United States conceals and does not as soon as possible make known the same to some judge or other person in civil or military authority under the United States in a physical sense of the word and not in the corporate sense of the word shall be fined up to $250,000 and or 3 years in prison when they do not tell on their cohorts and their co-patriots and their conspirators when they help each other to deprive you of your constitutional rights. Okay, 31 U.S.C. 3720D violates the separation of powers doctrine, which is wage garnishment on its face, and is a form of 42 United States Code 1994 peonage. Under threat and abuse of legal process as a consequence of their attempt to demand an employer not fire a supposed non-custodial parent, which is not us, which is the Social Security Administration, which is diminishment of my rights and title and status of man, being born free, equal, and independent, with full protection of the law equally, any other human being, and is the 20 CFR 422-103D registered property of Social Security Administration, and according to 42 United States Code 666 A3C is the First Amendment, freedom of religion, violating statute obligor, sanctioned under 31 U.S.C. 3720D, otherwise known as a non-custodial parent, which is not me. According to 20 CFR 422.107, it must provide its Social Security number to the, quote, Child Support Enforcement Agency, which is assumed, which is false advertisement because of Blessing versus Freestone, We Hunt versus Ledbetter, Corelli versus Hauser. Okay, you don't want to get me in a court proceeding. That's going to be a nightmare for you. You don't want to come finding me, 4D agents, bro. You don't want to come find me, okay? You know, just because I reveal my strategy to you does not mean anything. It doesn't mean you can beat it, because you can't beat it. So I'm done, hole. Thanks for playing. Game over. Have a nice day. Please insert token here. Try again tomorrow. Okay. We're going to move on. Okay. So we're going to tell you Blessing versus Freestone and children pursuant. Okay. So where were we at? Must provide its Social Security number to the Child Support Enforcement Agency, which isn't intended to benefit parents, men, women, or individual children pursuant to Blessing versus Freestone and continued diminishment of my book of Genesis status as man, being born free, equal, and independent, having been deprived my liberty in violation of the 13th Amendment by intrusion by a state agency or court, such arresting officer violating Chapter 77 of Title 18 of the United States Code under color of state law under the 42 United States Code 654 state plan. Okay, so you're going to replace Chapter 77 of the United States Code with your parental rights case law, case decision doctrine, okay, which is under my master index. You go ahead and look that up. You go ahead and look up my master index videos and combine those together and see how much of a force of reckoning you become to the United States or the several states or any other government alphabet group that wants to stand against you when you haven't committed a crime, which is all contained under Title 18. If you know Title 18, good luck putting you in jail. Okay? If you know your Constitution and your Bill of Rights, good luck putting you in jail with Title 18 even. Okay? Such arresting officer. Okay, so that was a 654 state plan. Now, I motion for summary judgment on behalf of the plaintiff and request damages real and personal under the 1st, 4th, 5th, 6th, possibly 7th, 8th, 9th, 10th, 13th, 14th, and 16th Amendments and 42 U.S.C. 1983. Your Honor. What say ye, court? The First Amendment right to familial association. The First Amendment right to intimate and expressive association, both with your human offspring and without the agency. Okay? Your Fourth Amendment right to be secure in your person, papers, and effects without unlawful intrusion under some sort of Weinstein scheme of lack of probable cause. Okay? So you got your Fifth Amendment right was violated under due process when they expedited process or when they enforce wage garnishment, okay, under 42 USC 666 with expedited process, okay, to ignore the requirement of due process under the Fifth Amendment. And then they deprive you of your Sixth Amendment right to trial by jury in their statutes for paternity proceedings, okay, and possibly your Seventh when they start getting into criminal and tell you you can't have a jury, okay, and possibly your Eighth when they deprive you of your human offspring. I would consider that unlawfully, and obviously the false accusations and documentation that you can prove is false that you have on the back end, because they don't know what they're doing because you've been collecting evidence. Okay, that's cruel, unusual punishment against you. And they also like to issue unlawful and unconstitutional bail conditions, such as restrictions on the First Amendment right to, freedom of speech, okay, and your right to work, and all these other types of conditions. On any unlawful bail condition, you can't be around your children. That's your bail condition. That violates the 14th Amendment, you idiot. Try again. Nice order. You go ahead and fucking enter an order. Sorry, I'm getting heated, but you go ahead and enter an order and see how fast I appeal. Also, if you're going to appeal, make sure you got a court reporter available. If you don't, make sure you demand that court reporter that was there for the court, and they have to have one, right? Whether it be an AI or whatever, is available to you, and then it matches up with your records. Always contain records. Okay, Eights. They like to do a lot of hokey pokey with the Eighth with your bail. And then the Ninth Amendment unenumerated parental rights under the Supreme Court case law. The Ninth Amendment unenumerated rights to not be subject to criminal activity. The 10th Amendment prohibition on states accepting anything but gold and silver as legal tender in payment of a debt, which child support is considered a debt. They like to call themselves state actors. Okay. And then the 13th Amendment prohibition on involuntary servitude on the living human being, okay, and on the corporate legal fiction, whatever you want to call it. If you want to say that they're one and the same, you would be incorrect and you would be committing perjury for and on the record. So you go ahead and open your mouth and you call me a sovereign citizen because I got 14th Amendment, equal protection of the law, and you can't deprive me of my privileges and immunities, such as the right to travel. You cannot convert my right to travel, okay, and my freedom of movement into a driver's license or a permit for a fee as a state, okay? That's a violation of the 14th Amendment. And when they take away your driver's license, they are doubly violating the Constitution because they are doing something unconstitutional by issuing the driver's license or any type of licensing to begin with as a state. They are prohibited from doing that constitutionally. They're not supposed to be doing that anywhere. Driver's licenses are void. Traffic tickets, all this bullshit. unless you hurt somebody, is void. If you get in an accident and you hurt somebody, or you think you got to speed without the skill to handle your vehicle, or you think you got to, use your vehicle to commit criminal activity, then the police are within their right to come hunt you down. Just so you know that. Child support's not positive law. They can't enforce non-positive law upon you, right? So the thing with 1983 is it's under Title 42 also, but it is a positive law title because it is also codified elsewhere similarly in 18 USC 242, which applies to all government officials. So does 1983. If you look in the statute, it says, or the District of Columbia. What is the District of Columbia? You're going to find out that's the federal jurisdiction. What is the federal jurisdiction? Oh, would you look at that? So it applies to federal officials too. So both codes apply to state and federal officials when they deprive you of your rights or your privileges and immunities under 18 USC 242. Okay? So 18 USC 228 is fucking kidnapping. That's also a violation of your right to travel. Okay? That's a violation of your freedom of movement and your right to seek an honest living, because if you're trying to pursue work in another state and they hold you for a felony for crossing state lines because you owe arrears, there's a problem there. That's unconstitutional. Okay, so I motion for summary judgment on behalf of the plaintiff and request damages. Okay, so when they go in with the 16th Amendment, how they do that is they commit the tax fraud by taking your tax money, your tax return money. The child support people do. They take your tax return money based on the fact that you owe the United States government a debt for a 4D contractual loan procurement program. Okay, so the 16th Amendment going after your taxes when it's a non-tax debt is tax fraud on behalf of the agency. On top of that, the IRS, Title 26 was never signed into positive law. So what fucking law obligates you to pay taxes? Another thing is that on top of that, the IRS is an executive branch agency. Congress does not have the power to delegate the ability to levy and collect taxes to the executive branch. The IRS is unconstitutional under the 16th Amendment. And 42 USC 1983. So you're going to seek redress. You're going to seek for your kids back, man. Okay? I'm going to list off a little bit of case law tonight that's going to defeat anything that they got coming. Okay? Blessing versus Freestone. United States versus Sage, We Hunt versus Ledbetter, Corelli versus Hauser, Holmberg versus Holmberg, Butts versus Economy, United States versus Lee, Bailey versus Alabama, Marbury versus Madison, Norton versus Shelby County, Maine versus Thibodeau, Schuer versus Rhodes, Santosky versus Kramer, United States versus Schroeder, Williams versus Reed, Murdoch versus Pennsylvania, Shuttlesworth versus Birmingham, Alabama, Owen versus City of Independence, Monell versus Department of Social Services, Miranda versus Arizona, Dwar versus City of New York, Fransoni Associates versus United States, Sherrar versus Cullen, Troxel versus Granville, Washington versus Glucksburg, Stanley versus Illinois, Smith versus Organization of Foster Families, Quillian versus Walcott. Okay, Clearfield Trust Company versus United States, Parham versus JR, Reno versus Flores, Mayer versus Nebraska, Duchesne versus Sugarman, Pierce versus Society of Sisters, Prince versus Massachusetts, Ginsburg versus New York, Wisconsin versus Yoder, Cleveland Board of Education versus LaFleur, Moore versus City of East Cleveland, Griswold versus Connecticut, Horton versus Breckler, Pennhurst State School versus Haldeman. Damn, that's a hard one. Schwar versus Bar Examiners, Simpkins versus Shalala, Owens versus Zucker at Allele, and Penhallow versus Doan's Administrators. These Supreme Court case laws state that they do not, or case decisions state that they do not, that stare decisis, that stand by the decided decisions, they do not get any immunity for their violations of constitutional rights. They do not get any immunity. They don't get to hide behind the guise of constitutional authority because they swore it off. They violated their oath. They are attempting to destroy the family unit. And I'm telling you, Donald Trump, thank you. Thank you for 42 United States Code 1981 and the executive orders on administrative law judges and the executive orders that you've put out on the Second Amendment and various other executive orders that I have looked into. Thank you. People don't know what all those mean yet, but it means you were supporting parents the best you could. I'm not talking non-custodial or custodial. Those words are a violation of parents' rights. Custodial, non-custodial. This system has plagued us long enough. It is a self-reciprocating, it's a self-regurgitating machine. All it does is make more cases for itself to litigate over and over and over, like a snowball. But there's not a snowball's chance in hell that they're going to win against you if you know how to prove and have the knowledge of all this information. You have to use what is available to you. Use their stuff against them. Find the federal manual of child support. Find the federal training manual for the CPS worker. Find the statute they're supposed to go by. Find how they're not going by the statute or the manual that says how they're supposed to operate that governs them. Use their dictionary against them. Show how their words are violating your rights, or how their words are a lie, or how their words are void. And I'm going to tell you right now, Bill Clinton, Barack Obama, Kamala Harris, Joseph Biden, Javier Becerra, Stephen Capps, Kent D. Angle, Aaron Frisch, okay? Tangular Gray, Tony Evers, Gretchen Whitmer, James Lankford, Andrea Palm, Anna Schroeder, Jane Carroll, Frederick Rosa, Carl Ashley, Kevin Martins, Mary Trigiano, Lee Dreyfus, Jason Michelot, okay? James Sullivan, okay? Janelle Elchala, Lisa Bangert. You keep it up. 18 United States Code for misprision of a felony, $250,000, 3 years in prison, felony. 18 U.S.C. 201, bribery. The Attorney General, Pam Bondi, and the Attorney General of every state, you better start litigating against the child support agencies and social welfare agencies now, because I'm here to tell you 31 U.S.C. 3720 C, not D. And if you go look that up, you'll see where the Attorney General is getting bribed to look the other way on the violation of your rights for the wage garnishment under the next title in that little thing they had going on there. So you go ahead and hit next and see the wage garnishment, which is peonage, which is the 13th Amendment violation, which is a violation of your liberty. You don't get to have slaves. We abolished slavery in this country for a reason. All right? Abuse and neglect. Okay, so for non-child support cases, you can use the parental rights doctrine. Okay, so I'll do that in a second. Okay, so 5 U.S.C. 3331, oath violation, removal from office, felony. 5 U.S.C. 7311, disloyalty, striking, banned from government, felony. 18 U.S.C. 1918, striking, $250,000, 1 year in prison, felony. 18 U.S.C. 242, color of law, under federal law, whether it be state, local, doesn't matter what government official it is. And with Title 18, you turn it into the Attorney General and FBI, but they get a bribe to look the other way, which is why they're not enforcing 18 U.S.C. 242. For my homie Chris Griffiths, who I haven't heard from in a while, and I'm worried about. Okay, that's $250,000 a year, or a life in prison, or if death results, death, or if kidnapping results, death. Okay, 14 U.S.C. 1981, equal protection of the law, compensatory contracts termination, so you get your money back. 42 United States Code 1983, color of law, state $250,000 or the state personal injury cap. 42 United States Code 1985, section 3, conspiracy against rights, compensatory damage, punitive, meaning criminal. Okay, I'm working on a fee schedule, so it tells the judge how much they're going to sentence the other party, which was the guy who used to be prosecuting you, but is now the defendant because they went ahead and violated your rights like an idiot. Okay, and you're going to take them and you're going to submit your interrogatories, which is your questions of federal law. Okay, I mean, look at all these rights you got here. Oh, I was going to do something real quick. It was the CPS. So for the CPS case law, what you want to do is you want to follow. Oh my goodness, I have it written down. You know what? Parham versus JR, Troxel versus Granville, Washington versus Glucksburg, Stanley versus Illinois, Quillian versus Walcott, Santosky versus Kramer, United States versus Lee, Butts versus Economy, Fransoni Associates versus United States. You can use this in CPS. You can use this in child support. You can use this anytime any public official or private person is colluding with a public official to violate you of any of your constitutional rights under color of federal or state law, meaning if they are pretending or lawfully claiming, okay, to be exercising legal authority over you, they're subject to this. So, Gunner, you still there, buddy? Sorry. That was a long one tonight. You still there? You can come on if you want, bro. But I'm just gonna free associate for the next what, 15 minutes. 15 minutes. What can we do for 15 more minutes with y'all folks? Oh, okay, yeah, yep, we can do this. Okay. Gotcha. I got one for you. So I'm gonna list off the codes that are relevant when it comes to understanding the legal system, understanding child support, and what's going on. It could be relevant. So 1 USC 1, person. 18 USC 3, 18 USC 4, 18 USC 6, 18 USC 7, 8, 10, 12, 13, 15, 16, 18 USC 18, 18 USC 20, 18, and you can tell 21, and then it skips 22, but then it goes to 23, 27, 39A, 40, okay, 49, okay, 152, 153, 154. I'm going to Title 42. 42 United States Code, 1985. 25 CFR 11.406. Public Law 90-284. Title 678, and that'd be 818. 28 USC 455. 18 USC 3571. 28 USC 453 through 455. 28 USC 3002, 15A, 15B, 15C. 18 USC 1090, 242. 42 USC 1983. You got 32 CFR 436.77A33. You got 42 CFR 488.301. All these different codes. I got so many codes, and I've got them on paper format. Yeah, it's ridiculous, dude. You know, you'd be here your whole life reading this shit. But yeah. So it's been interesting. So I'm gonna hit all 50 corporate states. I'm hitting all 50 corporate states. I've witnessed enough criminal activity, oath of office violations. I've seen enough. I know that our team's going through a lot right now. And I know it seems like there may be a wolf in sheep's clothes in your life. And there may be. It may be that baby daddy's after you. It may be that baby mama's after you. It may be that government agencies are after you. But I'm here to tell you we got a problem. Because these statistics, I can't even fathom. This has to change. And as fathers and mothers, this is our burden to bear. They took your children. They kidnapped them. Although the federal law doesn't allow you to prosecute them for kidnapping them because they consider that going across state lines, which would be expedited process for interstate placement of children. That's kidnapping. 18 USC 228. The only federal criminal statute making child support a felony. The only one is void because you cannot legally fail to pay something that is legally abolished. That a state cannot demand Federal Reserve notes in tender of payment for. Okay? Any debt or obligation are rendered null and void by the anti-peonage statutes enacted by Congress in response to Bailey versus Alabama's decision to remand and allow involuntary servitude. Or I think it was not Bailey versus Alabama, probably another case. But at any rate, we are coming. So many of these case law. I've read them all. I've read all these cases. Okay? You know, Washington versus Glucksberg was a case about physician-assisted suicide that established there is no fundamentally protected right to physician-assisted suicide, but there is a fundamentally protected right of parents to direct the care, custody, and upbringing of their human offspring, of which should be the example instead of what the complainant was trying to present. They wanted to die. So, you know, got about 10 minutes here. Things are hopefully looking up on my end as far as my personal life, and that's looking really swell. I'm trying to help several people. I've got more videos coming on my YouTube, and feel free to go watch those. That's Mr. Obsidian 8009. I've got stuff on child support. I've got stuff on CPS. I've got stuff on taxes. I've got stuff on police. I've got stuff on everybody and their mother, including bribes and everything else. And I'm not going to send it to them. I'm not going to blackmail them with it like they tried to do me. No, in fact, what I'm going to do is I'm going to turn them in. I'm just going to turn them in. I'm done giving them a chance to correct their error, because they're going to try to use that against me as some form of, you did something against me. So no. Yes, that's kidnapping. If they take your child out of state, if they transport your child or you in interstate or foreign commerce, which would be driving, which would be what the cops doing, because they drive for their job as a police officer, as compared to the private person who has the freedom of movement and right to travel. So they're subject to the Commerce Clause because they're traveling between two different states. That's federal, and that's the only time you can exercise the kidnapping statute. Oh yeah, of course. Thank you for willing to be here to learn all of this and to stand through this jabberwocky for the past hour and 52 minutes. I'm telling you, um, I'm gonna have to find some new content for next week, because I'm running out of content for you folks, man. Yeah, until one of us gets a win. I mean, maybe just free associate with some folks. Maybe I'll invite some folks on for a couple weeks, and until we can get some movement on some of these instruments. Again, fuck you, Maine. Fuck you. We're coming for you. You can kiss my ass. You can kiss all the parents' ass. You done fucked up. You don't get any federal funding. You can kiss our ass. You can kiss Donald Trump's ass. You can kiss Pam Bondi's ass. You can definitely go ahead and pucker up for John F. Kennedy Jr. as well, since he's the one that's in charge of revoking your federal funding, motherfucker. Excuse my language. I hate stupid people. I can't stand stupid, man. God, I can't stand stupid. And the longer you support these child support agencies, and the longer you let these CPS agencies into your home, the more they're gonna use it against you. And letting them into your home is a waiver of your Fourth Amendment right to security of person and security of private property. Okay? Answering their questions is a waiver of your First Amendment and 14th Amendment and Fifth Amendment, Fourth Amendment protected right to privacy, which you can protect by refusing to answer their fucking questions. When they ask you for identification, I'm sorry, my identification information is personally protected private information. You can suck a dick. First, fourth, fifth, 14th. Suck a big fat dick. As a good friend of mine would like to say, this is not the dick season. All right? It's not the season to be a jerk, and do unconstitutional shit. What if I just came up in your house as a social service worker and kidnapped your fucking kid right in front of you with the police with me unlawfully? What would you do? You wouldn't do fucking nothing. You wouldn't have the brains. They wouldn't have the brains to come down here and learn all their own goddamn stuff, man. Lord God, forgive me, for I know not what I do. Lord God, forgive me, for I know not what I do. Jeez. I almost did it too, man. You want to come on, Gunner? You can come on. Got about 5 minutes left. I just want to say I appreciate everybody for coming out, viewing the program tonight, coming out, supporting your boy, supporting the channels that I collaborate with, because we're all trying here, okay? And we got to stick together, because they're definitely trying to divide us. Whether that be race, gender, whatever. They're trying to divide you, man. these the gender affirming care and the gender dysphoria and all that, it spiked when the family court started locking up fathers for child support, because when dads aren't there to balance the family economic and show daughters what being a man is supposed to be, and show sons how you're supposed to act when you're a man, you're lost. You got a female being the male and the female for both the male and the female, which is why you now have transgender child. What is a transgender child? There is no such thing as a transgender child. You are not in the wrong body. You're not. You're simply not used to your body and don't know it yet. That's perfectly fine when you're going through puberty to have those kinds of concerns. There's going to be a lot of changes. But parents, it's up to you to teach your kids that, not the education system that's been handing out these sick, disgusting books. And we know all about them. And as for the deep state, we shit canned them and replaced them with some good folks. So I'm going to get out of here. You folks have a good night. Stay strong. God bless. Psalm 8:2. Go look that up.
In the United States, CPS makes upwards of $3 billion per day on trafficking and selling our children. The corruption may start with the caseworker, but goes through the judicial system, passing the governor through the Senate and into the White House. The entire system has a hand in the business known as CPS.
Our children are stolen every minute of a 24-hour day. They are being robbed of their innocence, their trust, their happiness. As parents, we are isolated and betrayed by a government we trust. States are balancing budgets on kids' lives. Only 12% of the kids taken will be reunified. Title IV funding is being riveted with fraud.
We need to stop CPS and abolish CPUthis.com is leading the way. Join us.